All right. Welcome, everybody. I'm attorney Justin Randall with Hooper Law Office. Our topic today is about planning, estate planning being an act of love, coming up with Valentines Day, obviously, I believe next week. So that's a reminder to everybody to get their flowers if they haven't already. I won't take credit for saving you on that one. But estate planning, just as much as anything else, can be an act of love because we're talking about planning for protection for beneficiaries or protecting them from not just things happening to them as people, but also protecting them from sort of the chaos that can come after someone passes away if things aren't properly set up. Unfortunately, you hear a lot of stories about that when someone has passed away and maybe the plan didn't function the way people thought it would, or they didn't have a plan at all. And so it was a bit difficult for them to deal with. So setting up that plan ahead of time is a really good way to make sure that you are protecting them from that situation. So just a couple of things I'll go through before I get too in-depth on things. Just a quick reminder for if you've ever watched this before, this is interactive, so you can submit Q&A. There's a Q&A function. I can see the questions come in, so I'll be able to answer them as they pop up. I'll glance over periodically to make sure I see them come up on the screen. Another thing is if anything we talk about today brings up any sort of concern for you, or you want to have a meeting with one of us, we do offer initial consultations. They're complimentary. So it doesn't cost you anything to come in and talk to us. So at the end of this session, you'll get an email with a feedback form that lets you fill out any feedback that you have, but also lets us know if you'd like us to set up an initial consultation. And then you'll also be getting a couple handouts from us as well. One is our a small part of planning that has a big impact sheet. It goes through a couple important documents that you should have regardless of the estate plan that you have. The estate planning pyramid is the other thing, and our estate planning pyramid, it's just the way we sort of visualize the important aspects of planning. And as the basis of the pyramid goes up, the things are still important, but the basis, the larger sections of the pyramid are more important to the planning. So, for example, the top of that is actually money, rather than that being the basis for everything. Money is part of a plan, but it's not the most important part. And then for our next week's topic, we actually are not going to be doing one of these next week. We have our public seminar at the Neville Museum in Green Bay. There's the 2 p.m. and 6 p.m. session. So you can sign up for that on I believe it's estateplanning.com, if I'm remembering correctly. Or you can call our office and you'll get scheduled for that as well. As seating is limited, so just make sure you sign up when you're able to. And then the following week after that, we're going to be talking a little bit more about long-term care planning and, planning when the right time for that planning is and what types of options you have to plan for long-term care expenses. So that'll be our following next week. So 2 weeks from now, our webinar. Okay, so getting started talking about planning around, those that you care about, planning for those that you love. There's two sides of that. There's planning during your lifetime, and then there's planning after you've passed away, right? And those are both very important. So planning during your lifetime, people think of an estate plan as how do we pass things on? But as I mentioned on that sheet with the 4 kind of key documents that every plan should have that you'll receive from us, you want to have certain documents in place during your lifetime to make sure that your loved ones have the ability to step in and help you if you are no longer able to do that yourself. So if you need them to act for you financially, make healthcare decisions for you, you want to make sure that they can do that. If they can't do that, it obviously creates a lot of stress for them, and there's only certain ways that they can get that authority then. So with those documents, you may have heard of powers of attorney before. There's really 2 types of powers of attorney when we're talking about it in this context. There's the financial power of attorney, or sometimes called the durable or general durable power of attorney, that helps someone step in for you financially or to sign certain documents for you. Those sorts of things are what are dealt with through a general durable power of attorney. And then there's the healthcare side of things too. So a healthcare power of attorney is the other main type of power of attorney that somebody would be dealing with. And you may have some of these already that you've signed in the past. And there's a lot of things that you want to keep an eye out for with your current documents to make sure they're the right fit for you. So with a financial power of attorney, like I said, it's mostly dealing with financial decision making, but it also has some legal planning options in there for your desired agent to step in and help you when you need help for those things. So when you're looking at a power of attorney for finance, you really want to make sure that you're setting it up with people that you trust, right? That's the first most important thing when you're naming somebody to be your power of attorney. If you have concerns about them, they're not really a good fit because you're granting a lot of financial and legal authority with that. And then the next is, do they generally get things done on time? You don't want a procrastinator responsible for paying your bills, right? That's probably not a good idea. Assuming they would also procrastinate for you. You want to pick the people who are going to get things done on time, who are responsible in that sense, but also that you trust to do what you would want them to do. And you're not worried about like someone coming in and taking money from you unfairly or stealing, your assets, because if that's a concern, they're not a good fit for that role. With financial powers of attorney, they're really, and this is where I was saying you want to take a look at your current documents, is they're really only as good as the documents that they actually, or as good as the authorities that are actually in the document, excuse me. So not all powers of attorney are created equal. You might have somebody with a financial power of attorney that they just downloaded from the state statutory form through Wisconsin. And that is a very bare bones basic form that doesn't give a lot of the authorities that I would want someone to have in the event that they were incapacitated. It doesn't give those authorities to agents. It's very general. Honestly, it gives basically one word descriptions of the powers it's giving, so instead of, I want my power of attorney to be able to write checks for me or pay bills or to open and close accounts or to move those accounts to different institutions if that's where they are better, providing investment opportunities for me. A lot of times the state statutory form, if it hasn't been edited by an attorney especially, will just say things like, I want them to have powers over banking or over, real estate. Well, what does that entail? That's a good question. I think it's open a little bit more to interpretation than you would want it to be. And when it comes to somebody needing to act for you financially, you definitely want to make sure that there's as little interpretation required as possible and that it's pretty clear. So if you don't, have those authorities in there, that limits pretty significantly what someone can do for you in the event that you are incapacitated. And there's really, at that point, only one way to expand on those authorities further, and it may not even work. And I'll go into that in a second. The next document, the healthcare power of attorney, this is what generally you would have seen at like a doctor's office primarily, where they say, all right, we need you to fill this out so that somebody can make healthcare decisions for you and end of life decisions if that situation comes up. The form at the doctor's office it's a valid power of attorney, right? It still functions as a power of attorney. The difficulty with any sort of form document you're filling out, though, is that they're not tailored to you or your particular situation. Forms are meant for the broadest audience possible. They are not drafted by attorneys that are sitting down with individual clients. They're drafted by attorneys that say, here's what makes sense for kind of most people. So a lot of times in that, the doctor's power of attorney form that you'll see, or the one that, at the form power of attorney, so to speak, is it doesn't allow certain decisions to be made if they're not opted into it, right? It may limit certain decision-making authorities that otherwise are just kind of the default, right? So you want to be very careful with when you're filling those out that you know what's all included in it and that you're not just filling it out to have it. Again, they work, they're powers of attorney, but you're always better off getting documents tailored to you and your situation. The healthcare power of attorney, one thing to keep in mind, and this is where, sort of as an act of love, this is important to consider, is this is the person who will be making end of life decisions for you potentially when that time comes, assuming it's not, you don't just pass away naturally and there's some sort of life support involved in that decision. The healthcare power of attorney and the physician are usually the two people who have to sign off on that. So you want to make sure that if you're putting someone in the role of the healthcare power of attorney agent, that that they're comfortable or as comfortable as one can be making that decision. If somebody would have a difficult time making that decision, it's not generally a good idea to put them in a position of having to make that decision. You want your wishes followed, and you don't want to be in a position where somebody may not emotionally be able to, right? And there's nothing wrong with that. It's just that they may not be the right fit. That person may not be the right fit for that role. So another thing with healthcare powers of attorney, you want to make sure that those agents actually have access to information. So a lot of healthcare powers of attorney, if they're drafted the way I would say you would want them drafted, is they'll include a HIPAA authorization in them so that those agents can actually talk to the doctor. But even if they have a HIPAA authorization in them, it's always a good idea to have a separate HIPAA authorization with all the people on there that you would want to be able to even just talk to the doctor at all. This is not decision making on HIPAA. It's just who actually can the doctor talk to about your health situation. It can be as simple as, can they even say what room you're in the hospital, right? As an example. Or are you even a patient of that hospital? They may not be able to give that information to those people if they're not on that HIPAA authorization. And this is a good idea for anybody over the age of 18 to have too. So another place where this active love can come into play is if you have kids, minor kids who are about to go off to college, and once they're 18, or they are 18 and they're about to go off to college, once a child turns 18, parents are no longer entitled to information, right? The law does not assume that parents get along with their kids, or kids get along with their parents. So you need to have, for your children, HIPAA authorizations on file with their primary care doctors, or with the doctor at their university that they're going to, so that you can actually get information if something happens while they're away, right? It can be very scary to know that just because someone's on your health insurance still doesn't mean that they are you're automatically entitled to information about their situation. And then with life support was something I mentioned earlier. You also want to make sure that you write down in a living will, or have drafted in a document called a living will, what you want to happen. So, do you want to be on life support? Do you want to be removed if you're not going to recover? What kinds of removal do you want? Like, is it just ventilators, or is it feeding tubes and ventilators? Do you have any particular religious wishes or desires that are need to be incorporated in that decision making? For example, certain types of faiths have different requirements in terms of what end of life looks like, and what types of life support can be removed. So if that's important to you, you want to make sure that that's spelled out. What the living will really does is it acts as a proof to that person having to make that decision that, hey, here's my legally codified wishes. This is what I want. You're absolving that person from liability for following your wishes. You're making sure that it's clear to everybody that this is what you want. And that there's no doubt about that. But it's always a good idea to talk with that person who may have to make that decision anyway, even though you have it written in a document, because you don't want them to second guess that document might have been changed, or that maybe mom and dad did change their wish, right? I mean, you want it to be very clear that those are your wishes. So those sides of planning, the reason that's an act of love in a lot of ways is because if you don't have those in place, the alternative is very messy. If you don't have powers of attorney, if you don't have your living will in place, if you don't have HIPAA authorizations in place, like I said, there's no authority then to make those decisions or to get information. And if you lose capacity before you can put one of those into effect, you don't have any authority in place for those people to act. And the only way for them to get that authority, if you don't have the ability to sign new documents, is for them to go through guardianship for you. And that can be a very difficult process for family members to go through. If it's necessary, it's absolutely a vital procedure to use, right? It's a process that exists for a reason. But if you don't have those, or it's entirely avoidable, I should say, if you have documents in place that are well drafted, that cover all the things you need them to cover, and are in place before you're incapacitated, right? I mean, having powers of attorney in place with all of the authorities that person could ever possibly need avoids a lot of the need for guardianship at any point. That's why it's so important to take a look at the financial power of attorney in particular, but also the healthcare power of attorney, I suppose, and look at what does it actually authorize that person? What does it allow them to do, right? Does it cover all of the things I would need them to cover? That's where one of the issues comes up a lot with some of the statutory forms for documents. With the financial power of attorney in particular, like I said, it's so simple, it's so simplified that it doesn't cover every possible thing that could come up. In particular, it doesn't cover a lot of options for planning around long-term care. And that is something that if you don't have those authorities that you need in there, you don't have the authority to act as a power of attorney agent to do those things. And that, even if somebody has a power of attorney like that, they still may need to go to guardianship or go through guardianship for that parent or loved one to be able to get those extra authorities that the document didn't already grant. And with long-term care in particular, the court is not going to grant a lot of those authorities. So it's very important to know what's in there now and make sure that it's sufficient for you, even going forward. Sometimes it can seem like overkill, right? Where it's, well, I don't need that now, so why would I have that authority in there? Well, it's because you don't know if you'll ever need it, and you don't want to have a family member go through guardianship for you for that authority just because that wasn't in there, right? With healthcare powers of attorney, where guardianship can still come into play for certain people, is one of the things that you have to opt into in a healthcare power of attorney is whether or not you want a loved one or that your healthcare power of attorney agent to be able to, for example, admit you to a nursing home. And a lot of gut reactions are, oh, I don't ever want to go to a nursing home, so why would I want that authority in there? Well, because at certain points in our lives, it may be that that's where the care is best provided, that our family members can't take care of us at home, or that it's actually harming us to not receive that care, right? So if your power of attorney for healthcare does not allow that agent to admit you to a care facility, and you do need that, they may still be back in guardianship petitioning the court for that authority, because it may be what you actually need at that point. So it's important to know that just because you want to avoid care as much as possible, that we all may need it at some point, and you don't want to preclude someone from being able to make that decision. So I know it can be scary to think about, but it's important to plan ahead for that sort of thing. Okay, so that's kind of the you during your lifetime side of planning for those that you love, making sure that their side of things is they have the ability to step in and help you, and they're not scrambling to figure out how to do so. Having those documents is key for that. Another side, kind of the other side of it for you, is the actual estate plan side of it, making sure that things are set up so that after you pass away, things go as smoothly as possible. And this can be in particular where we're talking about making sure that not only do you have the right estate plan for what you're intending to do, but also is it set up properly? Are your assets going to actually use that estate plan? So one of the biggest misconceptions that people run into is if you have a will, they think if you have a will, you're going to avoid probate, right? Or that the will controls everything that you own after you pass away, just because you have the will. Unfortunately, if you have a will, it doesn't avoid probate. Wills only control things that are going through probate. So that's a big issue if you're trying to avoid probate, right? If that's what you think is going to happen. The other side of it is if you have a will, wills, because they only go through probate, they also only control assets that are going through probate. So just because you own your home, or just because you have a bank account with beneficiary designations on it, or an IRA or 401k, any kind of asset, if those assets are not subject to probate, if they don't go through probate after you pass away, the will does not control those assets. So that is a big issue in particular, where the beneficiary designations on accounts don't match the will, right? So I've had situations before where a very well-intentioned person gave the advice of, oh, it's so much easier if you just put the person who's going to pay the bills, their name on the account. Well, the problem with that is they are then the beneficiary. If you had the will somehow set up differently, where maybe they weren't a beneficiary at all, or they were supposed to split the money, if they are the beneficiary on that account, they are now under no obligation to share it, right? They own it legally. So you may be asking them to make legal gifts in order to share it. And maybe there's reasons they can't do that from maybe they're on a means tested program, and that would cause a problem for them. So you want to make sure that if you have certain provisions in your plan, that your assets will actually use them. So with a will, that often means either directly sending things through probate or making sure that everything is set up so that they follow the will. And with wills in particular, you don't just want to mirror the beneficiaries on all your accounts, because that poses another issue a lot of times, where the personal representative, the executor, is what you may be familiar with. Their job is to take care of those expenses for the estate, using the funds of the estate to do so. But if they don't have any estate funds to do so because all of those funds have been already given out to the beneficiaries, then you've run into another issue of paying of expenses of where do they get the money to do that? If they are also a beneficiary, do they have to use more of their share to pay those expenses? So when you have a will, for example, you would want some assets to go through probate. There's really particularly one type of asset that you generally don't want to send through probate, and that's qualified retirement accounts. And that's because of the way the IRS rules work, that can force a 5-year payout for beneficiaries. So you want to avoid it for that asset in particular. But things like real estate, if you have a will, you want to go through probate. Things like bank accounts, non-retirement account investments, that things like that. There's nothing wrong with those going through probate. You want to make sure there's enough to make sure that that personal representative can pay expenses. With probate avoidance being a goal for a lot of people, which is why so many people kind of mess up their own will planning with beneficiary designations, is they're trying to avoid probate. So if you, for example, are using a trust to do that, it's incredibly important to make sure that you don't just have that empty trust, because again, a trust only controls what it owns. So if you're not sending things properly through that trust when you pass away, it's a very fancy document that doesn't do anything for you. You want to make sure that if you have a trust, you properly fund that trust, which essentially means, what are you titling in the name of the trust, or what are you sending through that trust after you pass away? And it's really important to make sure that that's set up before anything happens to you, because if it's not set up properly, it may be too late to re-coordinate that if you pass away unexpectedly, right? And then again, the kids may be ending up with a kind of a messy situation of, well, this is what the document says to do, but that's not what actually is going to happen, because here's why all the assets weren't funded properly to the plan. One of the most important things you can do with that is make sure you're working with somebody who will help you do that, whether it's your financial advisor, understanding what to look out for with how your estate plan works. Make sure they know what your estate plan is, for one. Introduce them to your estate planning attorney. Work with an estate planning attorney who helps you fund those trusts or helps you align those assets with your will, because unfortunately there are too many attorneys out there even that will draft a will and then say, okay, you're good to go, right? Well, what about all the assets? You may have drafted the will, but are you actually just giving them a false sense of security? So that's very important to work with people who do know how to fund a plan properly, who will help you do that, because it just makes sure that plan actually works. And that really plays into where this can be a really big act of love going forward for somebody, or protection for those that you love. Because in your estate plan, in your will, in your trust, you may have provisions in there that say, in the event that one of my kids or one of my grandkids has a disability, or maybe they're a child with supplemental needs, right? Maybe they need certain types of planning for them. And if they get money directly, that could cause problems. Maybe you want to prevent somebody with a substance abuse issue from, having access to those funds, but you still want to plan for them and provide for, maybe assisting them, but not giving them the control of those assets, right? Those are things that wills and trusts can do for you. But if you don't use those documents, none of those terms matter. If I have a child with supplemental needs that I've set up a supplemental needs trust for in my trust or in my will, if I just name them directly on all of my accounts, that supplemental needs trust never gets funded. It actually could cause them problems for their benefits if you leave money to them directly. So that's one example, but there's a lot of examples of what happens if a beneficiary is in the middle of a bankruptcy when they inherit? What happens if they're getting divorced when they inherit, or they've commingled their inheritance and now it's subject to a divorce? Or what happens if they're getting sued for some reason? I mean, there could be a lot of reasons that the things you leave someone may be subject to their liabilities. And so you can provide protection for that in an estate plan, in a will, or in a trust, but you need to make sure then that the assets that you have actually use those documents, because if they don't, that planning is useless. Like I said, it's a very fancy piece of paper that has a lot of good planning in it that may never get used. So it's really important to not circumvent your estate plan and not use it at all, because it does not just automatically control things. And a lot of people don't understand that, if you have a trust, but then you don't fund that trust, or if you have a will, but nothing goes through probate, they don't necessarily work the way they're intended to, or they may not work for or as intended at the very least. So you can protect those that you love from things that happen to them going forward too, but you need to use the plan that you've set up. And if you don't, that's where issues come into play. I'm not seeing any questions, but again, just a reminder, if somebody has any questions, you can feel free to submit to the Q&A box. I'll see them come up, or if you don't feel comfortable asking, that's totally fine. And I apologize. The website for signing up for the webinar or seminar, public seminar, is actually estateplanninglive.com or willsversustrust.com. So not just estateplanning.com, estateplanninglive.com. So to get back to the topic at hand, planning for those that you love, there's this lifetime side of it for you, making sure that somebody can step in and do the things you would need them to, so that they're not scrambling to, take care of mom and dad in a way that the only way they can, maybe through guardianship, but making sure they can do planning for you and can do protection planning for you if you need care, have all of the authorities they need to avoid guardianship. And then also making sure that the plan you have set up for them runs smoothly, making sure that your assets are properly coordinated with your estate plan, and that you're working with people who understand how to do that. I think where a lot of miscommunication comes in, and what we attorneys are just as guilty of this, not here, I just mean in general, attorneys are guilty of this, is they don't work with the other advisors in your life. So if you have a financial advisor, it's very important that your estate planning attorney knows who that is, and vice versa, so that they can coordinate and work together and make sure things work for you. If they don't work for you, you're in an unfortunate situation of, you pay a lot of money to set these up. You pay good money to do planning, proper planning. You don't want to not use that plan then. With no questions, I can see I'm getting close to time here, so I just want to leave you with a couple different things. That planning for the ones that you care about, you can plan ahead too. You may not have any beneficiaries with current issues in their lives that are concerning, that would cause a problem if they inherited money. That's why it's important to have provisions in there, though, that say, in the event that anybody who gets money from me through my estate plan has any number of these issues, here's what happens, here's how they're protected. So it's, planning for those that you love is not just about the issues that you currently know about. It's also about knowing, potentially planning for things that you hope never happen, but if they do, you're covered. It's an insurance policy in that sense against those things causing problems for the ones that you love. And making sure, in terms of the estate running smoothly, really making sure that if you're putting someone in charge of the estate, that they don't have to go around to the other beneficiaries getting money together to do that, but also then making sure that that person paying those expenses is obligated to follow the plan. So that doesn't mean leaving just the benefit, or just the trustee, or just the personal representative with an account to pay expenses. It also doesn't mean leaving all of those accounts directly to the beneficiaries. There are proper steps to do that, where both of those things can be accomplished with, quite frankly, no ability for one individual to easily mess that up if things are set up initially the right way. Okay, so with that, I can see I'm pretty much at time here, but I will let you guys go and enjoy the rest of your day. Again, just one quick reminder, the feedback forms that you'll get from us, if you want to set up an initial consultation, please feel free to fill that out. You will get, keep an eye out for that email, because you will also get some of the handouts I mentioned today. And if you're interested in attending the public seminar, please sign up on estateplanninglive.com or willsversustrust.com, or that way you can reserve your seat, because with any sort of facility, right now we're very limited in space, so just be very proactive with that if you want to attend next week. But otherwise, I will see you guys in 2 weeks for our next webinar topic on long-term care.